My understanding was that it was...
On Wednesday, the Supreme Court conducted a conferencing of over 20 appeal cases, which were filed before it. Among these appeals was the one involving the Attorney General and Mityana Municipality Member of Parliament Francis Zaake, challenging the Constitutional Court's decision to reinstate him as a commissioner in Parliament. Presiding over the conferencing, Justice Percy Knight Tuhaise ordered all parties to submit written submissions.
It's about protection of the Constitution. It's about protection of the sanctity of Parliament. You recall the Speaker was indicted by the Constitutional Court. Actually, she was condemned for that unconstitutional behavior and conduct which she exudes always, she exhibits in the way she presides over Parliament. And she was being restrained by court in acting in a manner that violates the Constitution, that violates the rules of procedure, that does not rhyme with the sanctity of Parliament and the Constitution. Largely, that is the gist of the decision. And we thought the Attorney General would swallow his humble pie and accept that indeed the Speaker acted in excess of the powers vested in the office of the Speaker. And indeed the Speaker has abused the authority vested in the office of the Speaker. The Speaker also exceeded the constitutional limits, the mandates given to the office of the Speaker. That is the essence of that particular judgment. And they wouldn't, but of course, they decided to appeal here, which is their right. And we had come here for directions. Indeed, the court has issued the same, to the effect that we should file, the petitioners, rather the appellants, should file their submissions not later than 14th of March, and we should also file ours by 28th of the same month, and thereafter they will give us notice for further management of the matter, including the date they will deliver their final decision. So our humble appeal to the Supreme Court is to expedite, rather our humble appeal to the Supreme Court is to expedite the hearing of this matter, to deliver judgment as soon as practicable, because it has dragged on for a long time, and indeed our client has suffered glaring injustice for a very long time, and the Speaker continues to violate the rules of procedure, to violate the Constitution with reckless abandon, with impunity. And the effect of this judgment was to curtail, to restrain her acts, to restrain her, to confine her within the constitutional boundaries, within the confines of the rules of Parliament. But that has not happened. She continues with her conduct. I hesitate to call it anything but that objectionable conduct, with reckless abandon and with impunity, which is really very, very unfortunate. So the reason we are appealing to the Supreme Court to expeditiously dispose of the appeal.
The appeal, what does the Speaker say?
Well, they are contesting the decision of the Constitutional Court, which for all intents and purposes amounted to an indictment against the Speaker for her obnoxious conduct. Because in that particular judgment, as I said, the Speaker was found in contempt of not only the rules of procedure, but in contempt of Parliament, which she presides over. And she was also found on the wrong side of the Constitution for acting outside the purview of the Bill of Rights, where she acted as a judge and prosecutor in the matter at the same time. And also she acted in a matter, rather she acted in a manner that in effect negated the spirit and letter of the Bill of Rights by occasioning mob justice against the Honorable Zaake, because members were just compelled by the Speaker to take that particular decision, if I may use that word, because there was no clear provision on which they anchored their decision. If you looked at the ruling, or rather the judgment of the Constitutional Court, they could not cite any particular provision under which they anchored, or rather on which they anchored their decision, because they suspended all the rules that that provided for the process for the removal of the Honorable Zaake from the commission were suspended. So, and now the question was, if you, after suspending the rules on which you are supposed to found or to ground your decision, then what is that particular provision supporting your decision? And so on and so forth. So quite a number of decisions that were made. But the long and short of it is that Parliament acted in excess of its jurisdiction. Parliament acted in a mob manner which is unconstitutional. And that's what the Attorney General wants to protect. And we are saying that's an absurdity.
In the Constitutional Court, the majority decision ruled that the then Speaker of Parliament, Anita Among, violated the principles of natural justice by not recusing herself in the matter in which she was a complainant.
This case has really affected us in a very, very grave way. Since that they brought this matter to the Supreme Court, they wanted us to forget about this matter. Of course, the intention, first and foremost, is to waste our time. They want us to get tired of this case. They want us to avoid it. They want us to just dump it. But we want to let them know that we are not tired. We are going to follow up this matter to the last dot to make sure that we get the justice that we need, that we want. We are fighting for justice. We are fighting for the rule of law in this country. That's the reason as to why I'm with the rule of law general here, to make sure that the law is respected. It is very, very, very amazing and not surprising that a full Speaker of Parliament did that kind of mob justice on me. Like how I've always been saying it, Parliament makes the law. But it is very disappointing that it's the same Parliament that doesn't follow the law. The Constitutional Court was very, very decisive in its ruling that Parliament is supposed to follow the law, and in that case, it never followed the law. It should implement the law. I was supposed to get back in the commission. They never respected that. They instead came to the Supreme Court to make sure that this case is stepped on. We are not going to give up on this case. We are going to keep on following it up to make sure that everything moves on in the way that it's supposed to be. So we are here to make sure that we get the justice that we need, and I'm thankful so much for my council, the Lord Mayor of Kampala, and also my party to stand with me, and we are sure that even Ugandans, they are making sure that Parliament is accountable to the people. They are making sure that Parliament follows the law. They are making sure that they are exposing Parliament. Each and everyone out there, expose whatever wrong that you see, especially in accordance to that Parliament, because it is Parliament that where Ugandans should have all their hope. But it's unfortunate that this is happening.
Other cases that were conferenced included Professor George Wilson Kanyaihamba's appeal, who is challenging the Constitutional Court's decision for dismissing his petition against the removal of bail for suspects in capital offences. Representing himself, Professor George Wilson Kanyaihamba informed court that he had already filed his submissions, but the submissions were objected by the Attorney General's office.
I came in this court. If you ask the ladies here and the judges, I gave them a copy of my book, the Blessing and the Joy of Who You Are. All the people here have it. They have my copy. What was I doing here? It is that day I gave them the copies of my book, my books, about 3 of them. They took their copies, they thanked me, and one of them came and collected another one from my own. What was I doing here? I was serving our submission. And we can go home, Wagamuno and I, we can prove conclusively that we served those submissions. I think people who know me to say I will give submissions in writing and I served the wrong court. Both our arguments and submissions in the Court of Appeal, which was the Constitutional Court, were in writing. And when the Constitutional Court denied our submission, we immediately appealed and asked to appeal in writing, and I came here, submitted an appeal. Then the others we served to the Attorney General and the lawyers of the NRM of our submissions to this honorable court. I think some investigation should be taken. Oh, we have no problem repeating the same request to this honorable court that if they are lost in the forest of this court, we shall go and prepare amendment, and within 2 or 3 days we shall submit the same, because this honorable court had graciously allowed us to submit our submissions in writing. And we hold you to that. Give us a day or two. It's not very difficult because we have our own copies we submitted, and we shall submit in writing. I think the people must be very careful to know that they are not gods. The assumption that I will be dead by the time the appeal comes in, and then nobody will argue with it. Forgot that I had a colleague called Wabamuno, Alex, and he would have carried on anyway. Secondly, I think I didn't hear any evidence of poison. He couldn't be just easily poisoned away. So, if they are missing, which is very strange, let the judges ask their secretary to check in their chambers, and if they are not there this morning, Mr. Wabono and I, we shall go and reproduce them. Within 2 days, they will be here. No problem whatsoever. If the learned judges of this Supreme Court had not given us permission to file written submissions, I am not, I think recently, those of you who attended the function of Thanksgiving at the Cathedral Mirembe and my residence will know that I am not a man who tells lies. So I'm telling the truth, but somebody somewhere managed to deceive the Supreme Court by saying I never submitted any written submission. They forgot about Mr. Alex Wapamuno, my co-petitioner. They forgot the other workers who work in this building, who saw me come with the documents and served them. So I am absolutely flabbergasted that it is a hearing and not a clarification and a judgment. Thank you, my friend.
In her ruling, Justice Person Knight Tuhaise ordered Professor George Wilson Kanyaihamba to file written submissions by March 14th.
The appellant will file and serve written submissions and authorities by 14th March 2024. The respondent will file and serve written submissions in reply, together with authorities by 28th March 2024. Then the appellant will file and serve written submissions in rejoinder, if any, by 8th April 2024.
The Supreme Court will also reconstruct a new panel to deliver a judgment in the case filed by the Attorney General against the former Nakawa Member of Parliament, Michael Kabaziguruka.
Because it is used as, being used as a legal instrument permitting the exercise of unlawful jurisdiction by a kangaroo establishment in form of what they call a court martial. To me, and to the law, it is not a court. It's it's a makeshift kind of arrangement, ad hoc, where you get Museveni's political opponents, dump them there, and give it a semblance of legitimacy by locking them up forever. Okay? Our argument is that the stay of execution is supposed to be interim. Secondly, the stay does not affect a declaration of court. So as far as the court system, as far as the constitution and the law is concerned in this country, there is no court in the court martial. It is just a disciplinary tribunal that is supposed to discipline their members. People like my client, the Honorable Kabaziguruka, who are not members of the court martial, who have never consented to their military discipline, cannot be subjected to the court martial. Well, the case filed by the Honorable Michael Kabaziguruka sought a declaration and obtained a declaration that the General Court Martial does not exist in accordance with the Constitution, has no powers to try both civilians and soldiers, because it's simply a disciplinary tribunal of the army. It is only supposed to listen to and take disciplinary complaints, like the insubordination, you did this, but not the conventional criminal complaints or accusations.
What made you hold the case? One would like, you talked about the death of...
Well, of course, the loser in the Constitutional Court, who is the Attorney General, sought to get a stay of execution from the Supreme Court and obtained one. But they still related to transfer of files from the military courts to the civil courts with jurisdiction. Okay? But they are using it as an instrument to continue trying, actually lodging fresh cases, which we think is wrong.
Okay, you said that the case was supposed to come for judgment. What happened?
Well, in the course of waiting for judgment after making our submissions, unfortunately, we lost two justices of the Supreme Court, the Honorable Justice Opiaweri, rest in peace, the Honorable Justice Stella Rachamoko, also passed on, may her soul rest in eternal peace. So the court has to reconstitute itself and write the judgment.
In this case, the Attorney General is challenging the Constitutional Court's decision when it agreed with Kabaziguruka's petition that court martial has no powers to try civilians.